The ruling made today by the Honorable Chief Justice in ordering that the statements of poll be handed over to the DPP and the Commissioner of Police is a ruling that is in consonance with all the general and acceptable established principles of law. Let's go back to basic. The statements of poll are public documents. They were posted up on each polling place at the night of the conclusion of the counting, and thereby they became public documents. In law, they constituted the first declaration of the results of the election in that particular locality. When aggregated together, they constitute the results nationally for both the national elections and the regional elections. Therefore, the documents, the statements of poll, were always made public. They were always public documents since the night of voting. The refusal, therefore, by the Elections Commission, and in particular the Chief Elections Officer, to disclose those documents to the media, to the political parties, to the stakeholders, and to the public was a decision that was perverted and wrong in principle from the inception. The second point I want to make is that under the law, the police has a power by virtue of a search warrant to enter into any place and to seize property, in particular property of an evidential nature. So we could have gone, or the police could have gone that route. Mr. Lowenfield, I believe, was written to, and a request was made for those statements of poll. That request was denied by Mr. Lowenfield, who claimed that he had some right to keep it for safekeeping. Yes, the Chief Elections Officer has a right in law to keep all election documents for safekeeping. He is the official legal custodian of all election materials. So he's right. But it doesn't mean that he is the exclusive keeper of the documents. Obviously, in appropriate cases, he would have a duty devolving upon him by law to part company with copies of those documents if the law requires their use in another forum. The third point I want to make is that the law is not an ass. The law will never create offenses in relation to an elections on the one hand, and then on the other hand, prevent relevant evidence from being adduced to prove those offenses, because the law would obviously be on a collision course with itself. The fifth point I want to make is that in law, evidence that is available, that is relevant, and that is probative is always admissible in a court of law. And a person who is in charge of prosecuting an offense before a court of law is entitled to possession of and use of that evidence wherever it is located in order to establish that offense. These are fundamental tenets of the rule of law and of the criminal justice system in most, if not all, civilized country. All those principles concatenate to justify and to render the Chief Justice ruling very sound in law. So I am not surprised that the ruling is in the manner in which it came down. That was always the legal position. It was untenable for Mr. Lowenfield to even think that he has exclusive control of and possession of these documents to the exclusion of the world. He has, as a statutory officer, the power to keep the documents, the originals, because of the office that he holds, for the purpose of future use. But that can be to the exclusion of the use for other purposes that the law designate these documents to be used for.